Well, I'm glad to introduce Dustin Lewis, who is going to lead this panel, and I will let him introduce the other panelists as they speak. But we're very grateful to him. He is the research director of the Harvard Law School program on international law and armed conflict. And he flew especially from Boston this morning at an early hour. And so he's one of the best experts on this topic. And so we're very happy that he has joined us for this conversation. I see there's some attrition this morning. I see that the reception last night had some, but I hope most of the retardataires come quickly. Okay, I'll leave it to you, Dustin.
Thanks very much, Professor Dano, and thanks also to Do for the very helpful coordination today. I'm going to spend about 10 minutes discussing two sets of questions to help try to frame part of the discussion today. And then I'll turn it over to Professor Walsh to talk about some of the follow-on considerations relating to state action and responsibilities in this area before handing it over to my colleague on my right on your left, Mr. Onishi from the ICRC, to discuss certain aspects of the benefits and risks concerning the use of AI in armed conflicts, as well as considerations around civilian risk in particular and deprivation of protections, before finally turn it over to Mr. Ito for some answers to some of the regulatory questions or some proposed answers with respect to autonomous weapons in particular. So with my 10 minutes, I'm going to be seeking to try to explore and frame for the discussion two sets of questions. And I'm very curious to get everyone's views in the room on these different aspects, because as you no doubt know, there aren't, unfortunately, a lot of agreed solutions and agreed frameworks as such that apply in relation to the development and use of some of these technologies. And we're needing to apply, by analogy, some of the existing frameworks. They raise quite complex issues concerning interpretation and application of the law, but they also raise questions at the operational and strategic and tactical levels as well with respect to the use of these technologies in connection with armed conflicts. If you pay attention to only one thing I say, I would ask that it be the following. I think it's really important for all of us concerned with respect for law and war to be thinking about what the conditions are for natural persons, so everybody in this room, in other words, humans, to be able to exercise when it comes to employing AI-related techniques and tools in armed conflict, the kind and degree of agency that would establish a legal link between that person, those natural people, and the conduct and consequences of the AI-related technique and tool. So how do we establish, what are those conditions that would be necessary? I have suggestions on some of them that we might think, but I think this is one way that's somewhat technology agnostic approach to this as we encounter seemingly asymptotic growth of the capabilities of these systems that are often labeled AI. So first, to set a definition, because most of the time when we talk about AI, we don't actually set definitions, and there's a real concern around terminological inflation in this area, and a little bit of foam, as they would say in Silicon Valley, around everything all of a sudden becoming AI to get lots of funding around AI. But what I'm talking about when I talk about AI today is around AI science broadly conceived, which relates to the development of computationally based understandings of intelligent behavior, typically through two steps. One is determining the cognitive structures and processes, and the corresponding design of ways to represent and reason effectively. And the second is to develop theories, models, data, algorithm, and constructed systems, whether robots or other things, that embody those understandings. And then these systems usually are conceived as acting more or less autonomously and reasoning more or less intelligently by doing things like interpreting natural languages and visual scenes, learning via training. So when we talk about learning, it's really using training for data, drawing inferences, making decisions and taking action on those decisions, that we want to avoid the anthropomorphization, of course, of the technologies themselves. as well as various other methods. So AI has been used in armed conflict at least since 1991, when the US employed the DART system to help its logistical efficacy and the speed of its logistical operations. But that was a type of symbolic reasoning AI. So when we think of AI, there's, so far as I understand it, there's more or less two different sets of methods, two different types of methods. One is model-based methods and the other is data-reliant methods. So the older versions of AI we talk about are symbolic AI or logical reasoning AI, as well as probability. These are two model-based versions of AI. But what most of us are concerned about today, when it comes to armed conflict, are the data-reliant methods, which involve statistical reasoning and data. So this is most of what we talk about when we think of the machine learning applications and whatnot. So that's what I mean by AI. Of course, there's no international legal definition of this, nor is there for autonomous weapons or whatnot. So when we talk about these things, I do think we should have some clarity around what specifically the object of concern is here. The two questions I will very briefly seek to answer, because now I've spent so much time on the definitions, relate to the implications for AI-related tech on state action and individual criminal responsibility, and who's responsible if an AI-reliant weapon is involved in a war crime. So for the first question, as most of you know, there's two forms of responsibility in international law, maybe three: state responsibility, individual criminal responsibility, and potentially international organization responsibility. There is no corporate responsibility writ large, nor is there non-state armed group responsibility, which some people identify as a normative gap in this area. When we talk about state responsibility, it's an internationally wrongful act, so a state hasn't performed some obligation. For example, the obligation on the state to ensure that it directs attacks only against military objectives under IHL. And that individual criminal responsibility imposes individual responsibility by identifying three aspects: the prescribed conduct, the mental state, and the mode of responsibility, in order to impose individual criminal responsibility, not only for IHL violations, but also for other violations of international law, whether for a crime of genocide, crimes against humanity, war crimes, the crime of torture, crime of aggression. Because we have no AI-specific regime of responsibility at the international level, we have to incorporate these existing cardinal frameworks, in particular state responsibility and individual criminal responsibility. One way that I think we might think about state responsibility here is to really narrow in on what are the obligations the state needs to perform with respect to a particular rule of concern. So whether it's the rule on distinction, on proportionality, or on precautions, what must the state do in order to perform those obligations, and to what extent may it be reliant on the AI-related techniques and tools? So from my perspective, I think sometimes lawyers are really good at completely overcomplicating things. So I'm going to try to distill this down into one sentence of what I think the state needs to do. The state, through the natural persons acting on its behalf, and this is the absolute core issue, it is through the natural persons only. There is no synthetic legal agency today. There's no robot or computer that has legal agency. It's the natural persons only acting on behalf of the state. So the state, through the natural persons acting on its behalf, must be able to put those persons in a position, and they must be in a position to ultimately sufficiently anticipate, administer, and trace the behaviors and effects of the employment of the AI-related technique and tool. Anticipate, administer, and trace. This is obviously a very wide framework, and yet hopefully it can be slotted into a lot of the different types of obligations. And there's a lot of work being done by words like sufficiently or administer, and what it means to trace the operations here, obviously also for anticipate. A key conceptual aspect here, though, is that it is the natural persons that are ultimately responsible for performing the obligations on behalf of the state. When it comes to the question of who's ultimately responsible for a war crime, who's legally responsible for a war crime if an AI-reliant weapon is used in the commission of a war crime, there's at least two different sets of actors that would be responsible. So one, most clearly, is the individual who is responsible for the decision to employ the weapon in the situation, in connection with the situation of armed conflict. This they could have done through any of the traditional modes of responsibility, whether it's direct responsibility, co-perpetration, And then also under Article 28 of the Rome Statute for the superior or command responsibility. But that's a very specific type of responsibility here. That's really only if you knew or should have known that a crime was about to be committed and you didn't take steps to repress it or to punish it after the fact. So what we're really talking about most of the time when we talk about war crimes involving AI-reliant technologies are the direct perpetration or the co-perpetration, and what some of the really difficult issues are here. And so most of the debate at the outset, especially in 2012 on autonomous weapons, was framed in whether a machine could be put in the dock, whether or not the machines would have legal responsibility. The consensus seems to be so far, at least in the context of the UN CCWGG on laws, 4 different acronyms all within one title, that it is only the natural persons acting on behalf of the state that can be individually responsible for this. So again, this question of what the natural persons acting on behalf of the state needed to do and when they needed to do it. As I mentioned before, there is no corporate responsibility as such. So if a state decides to adopt or utilize technologies developed by a corporation, the state must take sufficient steps in order to ensure that it is sufficiently reliable, such that the natural persons acting on behalf of the state can sufficiently anticipate, administer, and trace the behaviors and effects of those systems. Why AI-reliant technologies might be more challenging with respect to war crimes, there's a number of issues. Some of them are extremely doctrinal and technical. Other ones are a little bit more general. And I'll close here before turning it over to Professor Walsh to talk a little bit more about state action. So at the extremely technical level, for those of you interested in the sort of various aspects of a war crime, earlier I mentioned that you have to have 3 elements: the prescribed conduct, the act, right, that's prohibited, to be done with a certain mental state, and then done through a mode of responsibility. So it's in particular that with respect to the intent, with respect to the mental state and with the mode of responsibility, that some of the hardest questions on the reliance on AI might arise in terms of being able to establish individual criminal responsibility. So for example, what does it mean to intend to bring about a certain consequence in the ordinary course of events if you're utilizing machine learning technologies that are perhaps tested under a certain set of algorithmic and data-reliant frameworks, but then are using different data inputs during the actual employment of technologies? Can you say that somebody is exercising the type of intent that would be necessary for them to be able to mean to cause a consequence or to be able to anticipate it in the ordinary course of events? In other words, what does it mean to have an ordinary course of events whatsoever when you're using certain machine learning technologies? And another technical aspect here is what does it mean to, in terms of the co-perpetration model of war crimes, to have a coordinated essential contribution. So this might, for example, mean that you could fold into a criminal conspiracy is not necessarily the correct term under international law, depends on the customary status or the treaty under it. But in general terms, if there's a joint criminal conduct here, you could say, oh, it might be an essential contribution from both the developer as well as the person responsible for operating the system, the people responsible for ensuring the data is coming in. But it's going to be, I think, quite difficult in order to ascertain and ascribe responsibility under these traditional modes in a way that will be cognizable under the existing judicial bodies. Having worked at the ICC, I am someone who holds the international judicial apparatus in very high esteem, and yet I also think we want to be very clear-eyed around the limitations around the technical knowledge and the technical bases on which they can both discern what conduct has already occurred in armed conflict and to be able to then make judicial evaluations in relation to it. So with that opening set of questions, and again, with my core question being around what are the conditions necessary to ensure that one or more natural people in relation to these employments of AI technology can establish a sufficient legal link between that person and the causes and consequences of that employment. I'm going to turn it over to you, Professor Walsh, to help us think through a little bit more some of the core responsibilities of states, as well as the various due diligence and other obligations, and what sort of challenges and opportunities they pose for all of us in the room and for the international community more broadly. The floor is yours. Thanks.
Thank you. Good morning. It's very nice to be here, and I'm sorry I can't join you in person. I think this is a really timely discussion because, of course, the use of AI in warfare is not a theoretical question. AI-powered weapon systems are being used. So there's been reports of the Israeli Defense Forces using AI in targeting in Gaza. But of course, I think it was a SIPA report actually that described Ukraine's use of AI for intelligence, reconnaissance, but also for attacks and sabotage. So there are lots of views on whether we should worry about AI as enabling lawless killing, or whether it's kind of a smart way to confront aggressors asymmetrically. And so I think this is a fantastic discussion on how we can use ethics and law to channel AI productively. And it's a live concern for member states. In his recent report to the Security Council on the protection of civilians in armed conflict, and I'm just going to read a sentence for you, the UN Secretary General wrote, "Developments in the use of artificial intelligence and autonomous weapon systems may further increase the risk for civilians. They underline the need for legally binding instruments to prohibit autonomous targeting of humans by machines, along with autonomous weapon systems which function in a way that their effects cannot be predicted." And in the debate in the Security Council on Tuesday, there was lots of discussion among states about concerns with the use of AI. So I want to do three things quickly with my time. First is to talk about a range of state obligations with respect to avoiding harm through AI. And then secondly, and a bit maybe provocatively, ask questions about how we might think about meaningful human control, which is something that Dustin talked about. And then lastly, if I have time, just ask the room to think about whether we're bumping up against the permissiveness of international humanitarian law and whether we should be moving towards an approach of civilian harm mitigation, which is also something that the Secretary General talks about and recommends in his Protection of Civilians report. So first on state obligations. So in addition to negative duties to refrain from causing harm by employing AI, states have positive obligations to proactively protect other states and individuals from such harm. And what I'd like to lay out, and this is drawing on the work of a colleague of mine from the Oxford Institute for Ethics, Law and Armed Conflict, Talita D'Souza Diaz. I think we can see a patchwork of international obligations that require states to exercise due diligence with a view to preventing or redressing harm. So there's some general principles from international law, the Corfu Channel Principle, which is defined by the ICJ as every state's obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states. So here we might say, due to the unpredictable nature of AI, the key question would be whether and to what extent a state knew or should have reasonably known that a particular system would fail and cause harm contrary to the rights of other states. But we can also think more broadly of the no harm principle, which according to the International Law Commission requires states to prevent and redress significant transboundary harm originating in their territory. And unlike the Corfu Channel Principle, that principle has a gravity threshold. It must be significant harm. So we might think in the case of AI that states are liable for any use of AI in their territory, which causes significant harm to persons, property, or the environment in another state. So a second set of obligations, of course, comes from IHL, which also has some standards of due diligence that are required from states and other actors when developing, purchasing, selling, or deploying AI. So the first, and this got discussed a lot in the Security Council on Tuesday, is the duty to ensure respect for IHL. This is the widest and most important positive IHL obligation applicable to AI technologies. And it applies during peacetime as well as during armed conflict. It applies universally, and it requires states to refrain from committing or encouraging violations of IHL and to take positive steps to ensure that other entities comply. And it's interesting that it also claims that a lack of resources doesn't exempt states from compliance. There's also obligations around the development of new weapons. So states designing, developing, acquiring, or deploying autonomous weapon systems must consider all the conceivable ways in which their intended use might violate IHL. There's also, and Dustin mentioned this, protection of civilians' due diligence. So the precautionary duties that are of particular relevance for AI here are the duties to do everything feasible to verify that only military objectives are targeted, to take all feasible precautions in the choice of means and methods to avoid or minimize incidental loss of civilian life or injury to civilians, and of course, civilian objects, and then to cancel or suspend an attack as soon as it becomes apparent that the objective isn't a military one. Interestingly, you can also think here about positive obligations for defensive precautions, right? So states protecting their own territory and population against AI attacks conducted by their adversaries. And then finally, a set of obligations from international human rights law. So I don't know if you've discussed this before, but AI systems often impose unnecessary or disproportionate restrictions to human rights because many AI systems make decisions that affect individuals based on data and statistics that use proxies, right? And so we can think of obligations here for states, a negative obligation to refrain from violating the human rights of individuals within their jurisdiction, positive duties to protect human rights of individuals within their jurisdiction against any use of AI by third parties as well. So there's a number of things we can think about that states could do. We could talk about in discussion, conducting impact assessments, creating, as Dustin talked about, procedures for human oversight, also regulation, creating a comprehensive national framework, which isn't only necessary to protect human rights from the impact of AI, but also to satisfy requirements of legality when limiting the use and development of technology. And we can also think about here steps that could be taken to foster cooperation between states to prevent, mitigate, and redress the harms and risks of AI. So let me move just more quickly to my second topic, and I promised Dustin I'll only take a couple of more minutes, and that is this debate that you find in the legal literature around meaningful human control, and this assumption that the more human control, the better, right? And I think we're starting to see views expressed. I'm not going to say whether I agree with them or not, but they're out there, that the nature of these learning AI-powered systems may call for a reconsideration of this idea of the more human control, the better, because future learning, machine learning systems may comply with IHL just as well, if not better, without human control. So due to this incredible analytical capacity, these learning systems could merge the tactical, operational, and strategic levels of war and eliminate the delay or miscommunication that could be caused by feedback loops, right? So that view is out there. I think we should, using some of the concepts Dustin has talked about, problematize that. But certainly, and I'd like to end with this, we are seeing AI-powered databases used in targeting exercises. And I want to quote from a article that was in The Guardian about the IDF's use of these capabilities in targeting in Gaza. And were humans' roles in the selection process meaningful? And a particular member of the intelligence forces was quoted as saying, I would invest 20 seconds for each target at this stage and do dozens of them every day. I had zero added value as a human, apart from being a stamp of approval. It saved a lot of time. So there's a question here about, I think more broadly, whether IHL, and particularly the way in which it permits certain human casualties as incidental harm, we're really bumping it up against the limits of it. And I think this is why we're seeing a call from the Secretary General and others for states to be much more demanding in their approach to protection of civilians, to consider a standard instead of civilian harm mitigation. Because a focus solely on compliance with the law can imply that incidental civilian harm resulting from attacks that can be argued to be lawful under IHL still allow for a wide range of civilian deaths. Every day, civilians are killed and injured and experience long-term suffering as incidental harm. So I leave that with you because I think there's increasing discussion about this, whether we should be moving away from solely a compliance-centered approach, which also involves politicization of civilian harm, towards demanding, particularly in national protection of civilians policies, higher standards of civilian harm mitigation. Thanks very much, and I'll turn it over to the next contributor.
Thanks very much, Professor Walsh. There's a lot of grist for the mill in what you brought up, and I'd like to be able to get to the discussion really quickly, but just to highlight, I think this question of legal compliance and then things additional to legal compliance is a really important thread that we should pull on a little bit to figure out where those boundaries are and what the stakes are in those discussions, and what, for meaningful human control, for each one of those three words, which has been something of a term of art, of the political art of the negotiations around autonomous weapons, what they can and should mean for meaningful, for human, and for control. And then the additional measures that can be taken either as a way to implement compliance, to respect or ensure respect for the existing law, as well as to help ensure that there's diminution of risk at the international security level, including on things like cooperation and whatnot that we don't always see in the discussions. I think those are really important various measures. And lastly, this question of the range of normative and operational frameworks that ought to bear on these different issues, that it's, well, of course, international humanitarian law, the law of armed conflict, the jus in bello, whichever denomination you want to use, is recognized often as the principal legal framework applicable in armed conflict, that there are other normative regimes of various levels of applicability, depending on the state's concern, that ought also perhaps to guide our considerations related to what the core issues are that we're trying to deal with here at the values level, as well as at the operational level, and how to ensure the various things we want to ensure in connection with armed conflict and other security frameworks, whether it's protection of civilians, whether it's ensuring effective military conduct, et cetera. So with that, I'm going to turn over to my colleague, Mr. Onishi from the ICRC, to discuss two sets of issues. One of them relates to civilians and their protection or loss of protection for involvement in different technological means connected with armed conflict. Another one on the wider risks and benefits of using AI-related technologies in connection with armed conflicts. The floor is yours.
Thank you very much, Dustin. I'm going to take us out of this discussion briefly about AI and talk about digital technologies and new technologies, maybe that are a bit less high-tech and something that we're used to using every day. We've noticed recently three very worrying trends that are enabled by the use of digital technologies, and those are the increased number of hackers in armed conflicts, the use of certain applications and digital technologies for civilians to contribute to military operations, and thirdly, the role of tech and digital companies in armed conflict. So very briefly, hackers. We're seeing hundreds of hackers on each side of the conflicts that are taking up space in our headlines today. And with respect to AI, the barrier to entry to become a hacker and create malicious software has become much easier. There's something called Worm GPT, where somebody like me who has no background in computer science could potentially create malicious code. And we're seeing this being deployed in the context of armed conflict. The second trend we're seeing in some of these armed conflicts are civilians using, for example, apps to give information, for example, photographs, videos with maybe metadata that shows the location and time of military movements of the adversary. And if that gets transmitted to one of the parties to the conflict, that can be used for actionable intelligence, right? And thirdly, as you know, tech companies are leading very much on the digital front, and they provide indeed logistical support, technical support, cyber defense, provision of AI technologies, even offensive capabilities to parties to conflict. I should also mention that they provide satellite internet connection to parties to armed conflict. And indeed, what do these three trends mean? Well, from a legal perspective, it was mentioned by Dustin and Professor Walsh. There are the fundamental principles of IHL. Namely, I want to talk about here distinction. Distinction described as a cardinal principle of IHL, an intransgressible principle of customary law, is fundamentally important for the protection of civilians in armed conflict. In a nutshell, distinction requires all parties to armed conflict to distinguish at all times between civilians and combatants, civilian objects and military objects, and you can only direct your military operations and indeed attacks against combatants and military objectives. With respect to people, civilians are protected from attack, as I mentioned, but there's an exception. You can forfeit that protection for such time as you take a direct part in hostilities. We don't have time to go into exactly what that means, direct part in hostilities, but our concern is being a hacker, is providing actionable military intelligence to the adversary, does that count as direct participation in hostilities? Does that have you forfeit your attack, protection against attack? From the ICRC's view, in most cases, no. But again, it's about the perception of the adversary. In their view, in their interpretation, are you directly participating in hostilities? And so you might be opening yourself up to direct attack based on your engagement in the digital sphere. With tech companies, the same issue exists with respect to their staff, but also perhaps with respect to their facilities and their infrastructure. So IHL, again, protects civilian objects from attack. But a civilian object can become a military objective if through its use it makes a contribution to military action, and attacking it would render a military advantage at the time of the attack. It's possible that through some of these activities, technology companies are perhaps unbeknownst to them, allowing part of their infrastructure to become a military objective. I just want to highlight how important this is. Not only are you opening yourself up to direct attack, but you might also be exposing your surroundings to collateral damage, which could be lawful if it is proportionate. And so we've been very concerned about these three trends. And although I'm taking us away a bit from AI, I just thought that it was important to put that in your mind, given that the discussion is about new and emerging tech and digital. Coming back to AI, I want to talk a bit about how AI could help compliance with IHL and how it could hurt compliance with IHL. And I want to make a distinction here between autonomous weapon systems and other systems. So autonomous weapon systems, I'm going to crudely define them as systems that select targets and make decisions to apply force without human intervention. They're autonomous in that sense, and they can be powered by AI. I want to talk instead today about AI decision support systems. It's like you as a human are still making the decisions, but the AI is supporting your decision-making capabilities. So again, I want to talk about the conduct of hostilities regime, distinction, proportionality, and precautions, but zoom in on precautions here. Precautions, I think, gets underlooked quite a bit, but it really operationalizes distinction and proportionality. It's includes positive obligations directed at human beings, as Dustin said, we fully agree, directed at human beings to verify targets, to cancel disproportionate attacks, to avoid and minimize collateral damage, and take constant care to spare civilians from the effects of military operations. Again, these are positive obligations. I would even say it's like procedural law. If you skip this step, you're violating IHL, irrespective of what the consequences are. It might not be a war crime, but you're skipping a step that IHL requires you to do. These obligations must be conducted on the basis of all available information. And AI could indeed be helpful in providing more information about the presence of civilians, their movements, maybe collateral damage estimations. It could also assist in weaponeering, helping belligerents choose the best tactics, choose the best weapons that indeed could minimize harm to civilians. So very briefly there, that's more information the better, and AI can certainly help synthesize the vast amounts of data that could help for that purpose. But of course, there are risks involved. So AI make mistakes that humans don't make, very odd mistakes, and maybe we can get into those. AI can be unsuitable for certain tasks. Indeed, if you think about proportionality, weighing the anticipated direct military advantage versus the collateral damage, the incidental harm to civilians, making that calculation, which one is greater for the proportionality analysis. It's not obvious that AI is able to do that. It's not obvious that AI is able to take what it's learned in training and apply it to a completely new and fluid context where you also have the adversary trying to deceive you and not working and not working in an obvious way. Indeed, deception is a huge part of armed conflict. And there's also the risk of poisoning and making it so the AI malfunctions, et cetera, et cetera. That obviously has risks for the protection of civilians in compliance with IHL. But even if the AI system, the AI DSS system, operates how it should without malfunctioning, there are inherent risks we see in the speed and the scale at which the AI can operate. So speed, I mean, decisions that take hours can be done in minutes and seconds. I think we see that in our daily lives for those that have worked a bit with the generative AI systems that are there. We see how quickly that works. We also see how much data the AI can analyze and provide actionable information on. So what does that mean in this context? It means that the AI DSS could, if you're using it for target verification, provide hundreds and hundreds of targets at blazing speed, at which point the concern becomes, and Professor Walsh mentioned this, is the human actually interacting in a way that is allowing them to undertake the obligations under IHL, especially the positive obligations under precautions, right? Is there enough time for them to do that? And we're concerned that if left to their own devices of the speed of the AI, that those necessary steps will be truncated, which could result in civilian harm and indeed violations of IHL. And we also take into account things like bias of the human, automation bias. I'm guilty of it myself, believing what I see on my Google Maps. Okay, the train is running on time without checking other information. Does that make it so that indeed the human is not able to adequately judge and apply the obligations that it require them under IHL? Last point, if I may, just on autonomous weapon systems, very briefly. And this is in light of what Dustin has said. Indeed, humans must make the IHL determinations. This is clear from the fact that the wording of IHL, the nature of the obligations, and indeed what Dustin said, it's about natural persons at the end of the day. You cannot outsource decision-making at this stage to non-human decision makers under IHL. And we agree that there is this challenge that might arise in terms of intent, knowledge, mistakes, etc. Therefore, one of the recommendations that the ICRC has put to the SG, and indeed in our joint call for a binding instrument, is a prohibition of unpredictable autonomous weapon systems. Prohibiting unpredictable autonomous weapon systems should also play a role in mitigating some of the challenges that Dustin has presented about making the link with the natural person in terms of sort of state responsibility, but more importantly, criminal responsibility in this context. And indeed, for us, prohibiting unpredictable autonomous weapon system is central to ensuring that humans are able to make the decisions that are required under IHL. So I went a bit over, but I leave it there.
Thanks very much, Mr. Onishi. I again want to get quickly to the room, but just drawing out very briefly some aspects that I think we might consider for the discussion. This difference between natural and artificial intelligence and the role of the natural person in making the value judgments and the value decisions that are already required under IHL, including on things like whether a person's wounded and sick, whether there's a military advantage, whether a military objective contributes effectively to military action, etc. And then this potentially unwitting or witting endangerment of civilians and the civilian objects around them, as well as the natural environment, if they do involve themselves in war or in war fighting in ways that are increasingly available with things like, I hadn't heard of Worm or Worms.gpt. This sounds like something of potential big concern. And then this core question around the speed of AI and really shortening the OODA loop, the observe, orient, decide, act loop, which many militaries talk about when they talk about the advantage of the use of certain AI technologies and the speed here, and how then also to ensure what is the agent of compliance, or whether it's a natural person, whether it's a group of natural people, whether there is any form of synthetic legal agency that we might ultimately repose some legal agency in the machine. So far as I can tell, we have not yet, and whether or not that would be a good or a bad thing. And then lastly, on AWS, autonomous weapon systems, these questions of unpredictable autonomous weapon systems, what that actually means in both theoretical and especially in practical terms, and what it would mean for an autonomous weapon system to be involved in an attack that is directed not just against a military objective, such as a building, but also against people, and whether or not that might cross, if not a legal threshold, perhaps a moral threshold, or maybe a combination of the two. And with that, Mr. Ito, I'd like to turn over to you for a civil society perspective on ways to address the international regulatory apparatus concerning autonomous weapons systems. The floor is yours.
Thank you. Thank you, Dustin, and thanks to everyone. Like Professor Walsh, I want to also apologize for not being there in person, but it's really, really great to be here and be part of this very important conversation. So technology is actually changing the face of conflicts in a way that one couldn't have imagined decades back. And with it, of course, is coming a whole lot of challenges. And in my view, a whole lot of legal black hole that allows parties and governments and belligerents to sometimes figure out what rules apply and what rules that don't apply. And so, looking at it from the civil society perspective, I think the departure point for me is that the conversation about technology and conflict and protection and respect for international humanitarian law should actually proceed from a civilian protection-centered approach. And that is to say that we come to that conversation with the mindset of finding ways to ensure that we mitigate harm against civilians and that we protect civilians in times of conflict. Lawyers will always give you the answer you want. And so if the question governments are asking or armed groups are asking, how can we get around these rules, especially in the case of technology and international humanitarian law, there will always be answers. There will always be legal argument that supports one behavior, or legal arguments that try to insulate people who essentially hurt civilians, or in cases where there are clear breaches of international humanitarian law. There will always be argument to say, oh, it wasn't that way. It can be justified under the circumstance. And so, but if the approach is about protecting civilians, it changes the question. The question is about what can we do as a collective to ensure that we mitigate harm and protect civilians. Because every time we get wrapped up in the technical distinctions that you see in conversations around international humanitarian law, the people that suffer the most are civilians. And so when we talk about autonomous weapons, and of course the challenges that they create, I just want to mention a number of them to help build the argument that we really, really have to find a way to create a framework that responds to these challenges in their uniqueness and in their peculiarity. So the starting point is that we've had numerous debates about the fact that the legal responsibility for the use of autonomous weapon is not very clear-cut. Of course, when it's used in a particular country, we can of course hold that country responsible because the weapon or the device originated from them. But in terms of individual responsibility, it becomes a bit tricky. People have talked about automation bias, where in clear circumstances where you have some level of human control over these systems, because of the automation bias and complacency, people trust these machines more than they trust themselves. And they, of course, allow these machines to give out these instructions, carry it out, and in some cases, there are civilian harm. What this means for me is that even when we talk about human control, there is a huge possibility that in the exercise of that human control, humans will, of course, differ to machines. Because just as Professor Walsh mentioned, it saves time. And so in the best of intentions, we still have the challenge of exercising meaningful oversight on what these autonomous weapons are doing. The second one is the responsibility black hole. So there is this conversation about superior responsibility, where superiors in the military chain can be held responsible when people under their command, commit crimes or war crimes, as the case may be. And the question has been that, just like that's been said here, that these autonomous weapons are not human beings, they're not individual. And so the rule of the responsibility obligation becomes a little bit dubious under the circumstance, because you're talking about a machine and you're talking about a human being who is operating this machine, but without proper control of everything the machine is learning and everything the machine is interpreting. And so even the accountability nexus in this circumstance of a superior being held responsible by the action of the machine is not still clear-cut. The third point is that the autonomous weapons create an avenue where governments and military groups can outsource their responsibility and say, oh, we didn't anticipate this. We didn't know it was going to happen this way. But of course, the debate has been about when we cannot actually anticipate concretely what these machines can do, we shouldn't use them. But of course, there are no rules around this. It is still up to countries and groups to debate and agree on how they act under the circumstance. And the point then is that as much as possible, we need to acknowledge that the existing legal framework that we have does not adequately address the challenges and the new risk that these autonomous weapon systems are creating for international humanitarian law and for the protection of civilians. And looking at all of that, my submission is that we need to sit down and see how we can begin to develop a framework that adequately addresses the challenges that we see. Autonomous weapons pose a different kind of challenge in international humanitarian law to the protection of civilians. And we need to sit together to make sure that we create a framework that is adequate and responsive to those peculiar risks. We need to rethink the issue of responsibility. because there will be cases of willful blindness where people do not take into consideration all the available information around them. And it will be about, oh, this wasn't anticipated, and therefore somebody suffers. And perhaps part of this new regime of rules will be about strict liability. Strict liability for countries, strict liability for individuals who oversee these autonomous weapons. And so when a war crime is committed, it is not enough that you did not anticipate it. It becomes a strict liability. Of course, there's always this question about the mental element, which is a key component of culpability in the breach of international humanitarian law or in committing war crimes. And the issue, of course, is about, given that these are learning machines, the person operating them might not anticipate all of the dynamics of the algorithm that informs an action. And to that extent, you can then argue that they don't have the mental awareness of what's going to happen. And that becomes a key component of exculpatory facts around the breach of international humanitarian law. But if we begin to talk about the strict liability, the fact that the autonomous weapon has those potentials and that you are aware of it would not excuse the final details of those potentials that you're not aware of. Because if we are not able to get people to understand there are consequences and accountability for actions of autonomous weapons, countries who are interested in winning the war will always do whatever is necessary for them to win the war and come back with all this legal argument and all these legal exceptions to say, we didn't anticipate it. It wasn't us. The third point, of course, is the issue of transparency. What kind of information, what kind of learning are provided to these weapons? Because we know that there can always be information bias that makes this weapon to either breach international humanitarian law or unduly endanger civilians. And the transparency of what goes into that learning process is important. And what can help us to have that kind of information is, of course, a global framework that puts this on the table, that each country is obligated to make that information available, not just for the judicial process, but for a peer check amongst countries to ensure that the information that these machines are carrying are information that can actually understand the imperative of international humanitarian law. None of this can be possible if countries don't, at the national level, take steps to make rules, legislative, operational, that elevate the protection of civilians above conflict field victories. And so that countries must have to make laws, pass legislations, have procedures that, one, ensure that there are adequate human intelligence and human control of what these autonomous weapons are doing, to ensure that there are fail-safe systems to call them to order if it is seen that they are going to create undue harm to civilians. And thirdly, there's a learning process that every time these weapons are used, there are learning around what has happened with that operation to ensure that in future, more safeguards are put in place, that harms and attack on civilians are avoided. And also, in terms of indicating or establishing the mental element or the mens rea, as the case may be, if there are pattern of usage that shows harm, that should be enough to satisfy the mens rea requirements. And people who are involved in those activities should be held culpable. And the final point I want to put on the table is that in every conflict situations, as we have seen in Gaza, in all the places where we've seen war, countries are every time much more interested in winning the war. Countries are very keen in finding reasons to have an advantage over their adversaries. And sometimes those reasons are at the expense of the protection of civilians. Without a framework that is clear, certain, easily identifiable by every person involved in a conflict, they will always find excuse to do what is harmful to the international humanitarian law regime. And to that extent, we need to have rules that are clear and that are fit for purpose. And also, in instances where harm occurs, even if all the dots have been, all the T's have been crossed and all the dots have been checked, countries must also make amends when civilians suffer undue harm. Because from where we are seated, it doesn't matter what is proportionality. It doesn't matter what is legal. Whenever civilians suffer harm because of military actions, we must acknowledge it, we must amend for it. And I'll stop here. Thank you.
Thanks very much, Mr. Ilo. So again, trying to move quickly to discussion, just want to pull out a few threads here. So one thing I hear is concern that the role of natural persons might ultimately devolve to validating decisions that were arrived at by others or by different combinations of human-machine integrated formations that would not allow for meaningful type of responsibility. And also these questions around what are the interdependencies underlying our assumptions around attribution and application of legal responsibility. So what are those interdependencies involving the role of the natural persons, the role of the systems, the role of the data, the role of the algorithms, and also not just at the individual level, but at the state level. So what do we assume that, what are those conditions that would be necessary in order to ensure that at the state level, there's adequate systems in place to direct the people acting on behalf of the state, and that the systems are going to be sufficiently reliable in the circumstances of use? This very important question around what are the existing legal standards under IHL, and what are the existing legal standards for serious breaches of IHL, which are considered war crimes, including, for example, with respect to the notion of negligence or the ideas of strict liability, where if there's any harm, then you can find imposed responsibility, and whether things like fault should be an element of the legal regime, or what it really means to perform obligations, who's responsible for performing them, and to what standard, and whether it's a human standard or a machine standard, or if there's going to be some sort of combination of standards when it comes to the performance of those obligations. What it would mean to ground from the outset our concerns in this area around protection of civilians, and not just around military advantage or being able to win wars, but to be able to win wars in a manner that preserves these important developments of the normative framework. Of course, this week we're seeing protection of civilians debate at the Security Council, the 25th anniversary of this as a thematic area, and we're seeing on August 12th, the 75th anniversary of the signing of the Geneva Conventions of 1949. The fourth one is dedicated to the protection of the victims of war. So what does it mean for us as an international community to ground these discussions in 2024 in protection of civilians alongside of the other legitimate interests of states? And then lastly, this question around transparency. In some of the literature, there's this issue of what's called the double black box. Basic notion is that you can encase algorithmic opacity in military secrecy. For me, this is a very important matter because it goes to the heart of what it would be, what we can expect of the existing legal framework from a realistic perspective, from a practical perspective, and what it means to be able to, what we should be able to demand theoretically, conceptually, at the principle level of those responsible for conducting hostilities in the service of whichever country is involved in the armed conflicts. And so for this double black box of algorithmic opacity being encased in military secrecy, how do we deal with this? How do we conceptualize it? What are the issues? Are we actually that concerned about it? And what would it be like to meaningfully address that, either through technological means, through strategic, through operational, through normative regimes, and how to be able to do that? And with that, I'm going to open up the discussion to the room. Thanks.
Thank you so much. I've been reading a lot of what each of you have been writing on this topic, and it's just fascinating, so rich. So thank you for bringing this to us today. I do have a lot of questions, but I'll try to restrain myself a little bit. One is, and again, I'm not a IHL lawyer, so just that caveat. But in terms of, you mentioned this like predictable effect, and I guess due diligence. Has there been a discussion about how well indeed one ought to understand how AI functions, and if so, who should understand it. Dr. Walsh mentioned this notion of the 20 seconds of the Israeli officer, that was the time taken to decide based on the input was received. So I'm assuming that's not the point where you're trying to understand how the advice was arrived at. And also related to that, if there's only 20 seconds to decide by sort of the executing officer, yeah, how far has one gone in programming these systems when it comes to obviously target detection? There's a question of distinction. So what errors, or, you know, I heard Trevor Noah engaging in this conversation just to bring him in, but saying that he found out one algorithm was performing badly, particularly in Africa, because it basically used makeup as a proxy to distinguish between men and women in a data set. And we've seen this with cats and dogs and whatever, right? Like if it's unsupervised learning, random signals will be used for distinction. So I'm just really curious technically, like how do these systems distinguish between civilians and combatants? And has there been programming also at the level of proportionality? Is that like, yeah, so basically is that the programmer, or is it the human deciding things that looking at that? Yeah, again, with legal responsibility, just curious if one tries to make it concrete, you know, there's a person curating a data set and deciding that whatever model derived from that is used in another context. And then there's a person maybe setting some thresholds, and then there's a person executing. So just at each of these levels, again, in practice, how do we ensure either the protection principle or compliance with IHL is indeed complied with? Thank you.
Thanks very much for that question. So maybe, Mr. Onishi, I could turn to you on predictability and unpredictable, because I know this is an aspect that ICRC has thought a lot about. And Professor Walsh, then coming to you on due diligence, and to build out a little bit more, perhaps, these considerations around due diligence. And then, Ms. Sheila, if you'd like to jump in on these questions on proxies for legal characteristics, or on these sort of proportionality and other legal responsibility concerns around the what some people characterize as a responsibility gap, or this responsibility diffusion in this area. So over to you, Mr. Onishi. Thanks.
Thank you very much, and thank you for your very difficult and important questions. But on predictability, indeed, it's not. I can't give you the full list of what a predictable AI would be, a predictable autonomous weapon would be. But one of the things that we're concerned about is the employment of machine learning, particularly after it's deployed. If it were to learn in a way that maybe humans won't be able to understand immediately or at all, that would be one factor that would need to be regulated in terms of indeed stopping an autonomous weapon system from eventually acting unpredictably, even if it wasn't at the stage that it was deployed. In terms of explainability, which is also linked to predictability, recall that under Additional Protocol 1, there's an obligation to review not only weapons, but also anything related to tactics and methods of warfare. And indeed, that obligation starts rather early in the process. You would have to be able to explain how an AI or autonomous weapon system functioned in order to adequately review and indeed be certain that it can comply with IHL. So that's one area where we see that the explainability factor would have to be discussed. Even if it doesn't fall under this Article 36 review, again, I'm so happy that Professor Walsh mentioned Common Article 1, the responsibility on all parties to armed conflict and all signatories to the Geneva Conventions to respect and ensure respect IHL. There too, we have this obligation, including in peacetime, as she mentioned, where you would have to be able to explain how the system worked in order to respect and ensure respect for IHL. Maybe I'll leave it there.
Thanks, Professor Welch.
Yeah, great comments. Just when thinking about how you can operationalize some of the due diligence principles that I was mentioning, I mean, I think I mentioned them very quickly, so I'll elaborate, and it echoes what's been said, but I think here an impact assessment where you're ensuring that the AI is sufficiently predictable, or some have talked about reasonable standard of predictability before deployment. And then, as was just mentioned, an ability to understand and explain and how and why an algorithm reached a certain decision, and identifying potential harms caused by the machine and being able to mitigate them. I think also human oversight, as we've been talking about, creating that link, but also potentially regulation. So enacting a comprehensive national framework, which is not necessary just to protect, which I think a lot of states are thinking about, human rights from the impact of AI, but also to satisfy the requirements of legality when limiting the use and development of the technology. And that has to be put in place prior to the development, sale, acquisition. And I think sale is becoming really important. Again, just reflecting on the debate in the Security Council this week, there was so much discussion about arms transfer and the sale of arms and the obligation of states, particularly if they've signed the ATT, the Arms Trade Treaty, to be sure that weapons or weapon systems they provide are not going to be used in ways that will violate IHL. And then I think other due diligence measures, which are much more speculative, but just basic capacity building, right? So further research on AI, civilian and military training on the inner workings of AI machines, and then civil society awareness of AI limitations. And then the creation of institutional arrangements to independently audit. And this is also part, I think, of this Article 36 discussion, reviewing AI technologies over their life cycle. Because I think what I mentioned in my remarks about cooperation between states to prevent, mitigate, and redress the harms and risks of AI, yes, I absolutely believe this is necessary. I worry, though, we're not in a geopolitical moment where we are all that successful in this kind of intergovernmental cooperation. I've been following the pandemic treaty as well in Geneva, and even on something like pandemics, we're finding it very hard to cooperate. So that's why I don't want to hang my hat only on those measures, but also really hammer home what states need to do in their national policy. And just one final quick comment I would make, just to elaborate on the article I was talking about from The Guardian. The way that AI-powered databases were being used in this case that was being discussed, where I quoted from the officer, was that they were identifying a huge number, thousands of potential targets based on apparent links to either Hamas or Palestinian Islamic Jihad. And then what the article describes is that those targets that were generated were then attacked by unguided munitions, right? Some people call them dumb bombs. And they destroyed entire homes, killing all the occupants. So there's multiple forms of harm we can talk about here, but it's in that initial list of targets and then the decision whether to go ahead, that the quotation I gave you about the kind of 20 seconds for each target came into play. So I just wanted to give you the full sense of what was being described there.
Thanks very much, Professor. Mr. Iwo?
Yeah, thank you. I think Professor Walsh actually covered most of the points, but just quickly to add two things on the illustration she gave about the article in The Guardian. There was also this allegation that there was a deliberate determination to expand the scope, the ratio of collateral damage in those attacks. And that determination somehow informed the information the AI was generating in terms of attacks. And so somehow it was okay to, because of one person, level a whole household. And so it brings me to the point about establishing this threshold. or having some common standards about the kind of learning that are imputed into these machines, and making sure, even in a world in crisis where we can't agree, that we agree on certain basic standards, certain basic threshold of proportionality. You know, it doesn't make sense because of one person, you kill 20, you kill 100 people. Some of those basic proportionality conversation, due diligence conversation, care and protection of civilian conversation, I think there are enough commonalities and interests across various countries to use those basics to begin to build gradually a threshold of what these machines can be allowed to do and not programmed to do. So I'll stop here.
Thanks very much. And trying to build on each of your inputs here, there's 4 aspects I would highlight. So the first is, I think Professor Walsh was extremely diplomatic in setting out the current geopolitical environment. From my perspective, there's an enormous amount of mis and distrust among states, not least those states that have are developing or seeking to procure the military capabilities that we're talking about right now. And is in this environment, though, I think we want to have a lot of clear eyes around what the environment that we're entering into really looks like on a day-to-day and year-to-year basis here, and who benefits and who loses if that mistrust and distrust continue to operate, or if we might be able to take measures to increase some trust here and what that might look like. Second point is getting back to this interdependencies and interrelations. From my perspective, there's at least 3 sets of interdependencies here. So one is on the natural person relying on the technology to be able to do what that has been promised to do through testing, verification, et cetera. Second one is the natural person, so the humans operating on behalf of the state can rely on each other. They know that the person who did the concept of the operations in order for the tool itself, the person responsible for testing it in the circumstances of potential use, doing the legal assessments, all the way up to the operator employing it and the people doing the after-action review. They need to be able to trust each other. And then the third level is a more vertical level, which is on the state itself. So you need to be able to assume that your state has sufficient policies in place in order to ensure that it is discharging its obligations from the beginning to the end of the process. And on that front, I think this framing of sufficiently anticipating, administering, and tracing is obviously quite generic, but might provide something of a useful conceptual framework. And on the trace part, I think the law already actually requires states to employ only those technologies that are capable of being traced. Otherwise, you can't do an assessment as to the legality after the fact, including with respect to war crimes. So under the Geneva Conventions for Grave Breaches and Additional Protocol for War Crimes, states are obliged to investigate and prosecute or extradite people accused of having commissioned war crimes. And from my perspective, you can't actually do those investigations if you don't already know what happened and have the technical means in order to discern that. So if you're employing AI-related techniques and tools that are not susceptible, at least to internal scrutiny, I think this would already actually be difficult to square with notions of legality. On this numbers issue, I think it actually cuts both ways. Ultimately, these AI systems, especially the statistically based ones, statistical methods, involve ones and zeros when it comes down to it. So when it comes to, for example, the question of proportionality, this cuts in 2 different directions. On one hand, you could actually be able to trace what the number was. And armed forces, in my experience, are extremely reticent to say what the number, in quotes, is when it comes to the assessment of incidental civilian harm in relation to the military advantage. They won't say it's 3 to 1, it's 7 to 1, it's 10 to 1. And understandably, because it cuts in the other direction, which is that, as others have said here, there are certain evaluative decisions or value judgments that are required in the law, including around proportionality. And these are for me, very difficult to compare things. One is incidental civilian harm, and the other is the military advantage anticipated. Right now, so far as I can tell, most legal advisors say that decision must be made by a natural person. It cannot be reposed in a synthetic agency of a machine itself. And yet, you would be able to get the number issue you would be able to ultimately look afterwards if you did propose it in a synthetic system, because it would have a 1 and 0. So I'm not saying that this is an easy set of questions, but I think we want to think very widely on what we gain and what we lose by preserving the certain things. And the last point is a very, very broad one, which is all of these questions, including what Mr. Ilo was mentioning, bring up for me, what can and should we demand of a system of legal protection in war? What's actually realistic, and what's the principled way of doing this? What can we learn from the last 25 years, the last 75 years, and what sort of future do we want to have in 2030 and 2040? Because the armies, the armed forces, they are preparing for that now. As are various MFAs and whatnot. What can and should we demand of this? Because if we don't think, I think, very widely on this, we will be focusing too much on the nuts and bolts and not more widely on the ultimate values we're trying to instantiate through the legal system. Other questions from the floor?
Okay, thank you very much, Julia from Austria here, from the mission in New York. I had a lot of questions. Some of them were answered already, so I'm going to jump in with another one. On the question of terminology, I see a lot of work ahead of us, especially we've heard this week that AI is like an enabling capability. It's not one capability, it can be a lot of different things. So when we talk about autonomous weapon system, do we talk about intelligence research? Do we talk about the weapons being autonomously deployed? Like you touched upon a few examples, but maybe you can go a little bit more into this big difficulty of defining what we're actually talking about. And then the issue of proportionality that you said, and it was mentioned by Professor Walsh, like impact assessment. War and armed conflict is a very messy environment, and all these systems are trained on data of situations that happened before. So when we actually go into a very messy armed conflict situation with a lot of stakeholders, like, can the consequences actually be anticipated? And what you just touched upon now on the question of what kind of world do we want? What would this protection of civilians approach that was talked about, if we look at it from that lens, what could this look like? If we actually go away from asking, how do we train this? What do we have to anticipate in a battlefield? Like, can we take a different lens, and will that actually help us in moving forward? Thank you.
Yes. Hi, I'm Diane from the Philippines. Thank you to our panelists today. Your material that you gave us for reading was very thought-provoking. And thank you, Dustin, for mentioning about reducing the life into zeros and ones. I was very much bothered by the idea of how, like, conventional weapons. I don't even know if we have a basic standard for proportionality. So if we allow the machine to determine a certain number, maybe it might think that, oh, in the past, 1,000 is acceptable number. So in other future conflict, if only 1,000 people will die, and then that's okay. So the machine might think of it that way, and it's worrisome. Allow me to ask two questions. Dustin asked you asked earlier, Dustin, about what should we demand coming from the coming from the global South. What I wanted to ask is about, you mentioned that there's a requirement, let's say for Article 6, for a weapons review. For the Global South, in the discussion so far happening in Geneva, is there already an identification that there's, I think, lack of capacity in the Global South for this, for at least the weapons review, and is capacity building for weapons review part of the current discussions? And then number two, I remember in the Manila meeting on lethal autonomous weapons, Judge Pangalanan of the ICC mentioned about diffusion or dispersion of responsibility. Maybe you can walk us through about this concept, because I'm wondering if does this exempt, or because I'm imagining that as Mr. Wu mentioned, there should be strict liability strict liability with respect to state responsibility. But with the idea of diffusion or dispersion of responsibility, before the autonomous weapon system is built, many took part in building that. or even until you press that button of attack, many went through the process. So whether the diffusion of responsibility, does this exempt or mitigate responsibility of, say, individual or state actors? Thank you.
Thank you. Good morning. My name is Gideon. I'm from the Kenya Permanent Mission here in New York. There is one question or a comment that we had the day before yesterday, just in this room, is about protection of civilians by making weapons more smarter and precise using AI. What is the reaction to that? Instead of going back, is making them more smarter and precise. Thank you.
Thanks. And just confirmation on how much time we have. Maybe then I'll turn to Professor Walsh and then for Mr. Elo for any comments you want to have on this wealth of great questions before we turn over to the in-room discussion of the quick break. So Professor Walsh, I'll turn to you first, and then Mr. Elo with any comments on these great questions or any other considerations you'd like to leave the room with today. Professor Walsh.
Yeah, I'll try and be brief. I think the last point was fascinating in terms of, we have the capacity for much more precise weaponry, yet at the same time, this capacity is being matched in real time by incredible suffering of civilians in situations of conflict, which suggests that we need absolutely to double down on compliance with existing IHL and accountability for violations, and including other mechanisms beyond the Geneva Conventions. The political declaration on the use of explosive weapons in populated areas is an example of an effort to go beyond strict IHL and try to create more political commitment. But there was also a question asked about, what it would mean to take more of a protection of civilians approach. I don't have much time here. I would really urge you to read the last part of the Secretary General's last report on protection of civilians, where he begins to lay that out. But what he really asks states to do, and I think this is important, is to develop national protection policies, protection of civilians policies that establish institutional authorities, responsibilities for the protection of civilians and civilian objects. And you've seen some governments doing this. I mean, the United States Department of Defense has a civilian harm mitigation strategy. The UK has developed a protection of civilians policy that, yes, incorporates IHL, but from what I understand, is going beyond that. And so I think these are steps we need to think about, given the permissiveness of IHL and the way that it is being interpreted in contemporary armed conflict, but that in no way detracts from our need, broadly, state civil society, to advocate strongly for compliance with existing IHL.
Yeah, from my end, I mean, these are all great questions, and of course, wouldn't have enough time to go into all of them. But I want to leave this conversation with 3 points. One of which is my starting premise when I made my initial intervention about a civilian protection-centered approach to the relationship between technology and the protection of the respect of international humanitarian law. And of course, going beyond just that and talk about human dignity, morality, and ethical use of weapons. If the starting point is about ensuring that protection it will give answers to some of the questions we're grappling with here. And that is simple, that when people are not sure of the impact of the weapon they are deploying, they don't use it, because then they realize that it's going to hurt civilians. And when they deploy it, they take steps to learn what it has done to ensure that they improve accuracy and ensure that they are mitigating civilian harm. And when it harms people, that there are efforts made to make amends in those circumstances. The second point is that every time countries look for the weakest point of international humanitarian law regime, and they use that weakest inroad to advance their military advantage. And for us to limit those black holes that we already see because of the advancement in technology, we need to come together and review the existing protocols, the existing conventions, and make them respond to these new challenges and new capabilities that we're dealing with. The third point is that autonomous technology can actually be used for good in limiting harm. I mean, we must acknowledge that there are some precise strikes that help to mitigate harm. Perhaps government should focus more on those kind of machines and weapons to make sure that, again, technology is serving the best interests of civilian protection in these conflict situations. Thank you.
Excellent. Thanks very much to our online participants. I believe we're going to take a short break in the room.